They don't want her deposition transcript getting out there. Betty Poop's legal team was accusing Baldoni's attorney, Brian Friedman, of defaming her. Defamation is a very serious allegation for one lawyer to make of another lawyer. And in their letter to the judge, the Baldoni Wayfarer legal team says that upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then that part was redacted.
And this is a big update. Now, we don't actually know what was said. To be fair, it's redacted, which is good. It's still under seal, as it's supposed to be. But it heavily implies that Blake's team doesn't have anything to not only prove the retaliation campaign, but this ongoing smear campaign that apparently has been happening not only since over the summer, but now throughout 2025, which makes no sense.
Why would one of Hollywood's most bankable stars spend tens of thousands of dollars per day just to keep 292 pages of her own words under lock and key? Last week, Blake Lively sat for a marathon deposition in her $250 million harassment and retaliation suit against director-turned-adversary Justin Baldoni. Within hours, Baldoni's attorneys uploaded the entire rough draft transcript to the federal docket, then almost cheekily asked the judge to keep it sealed for 7 days so Lively could decide whether she'd like permanent secrecy. To Lively's camp, that move was a PR ambush, engineered to paint her as terrified of transparency. To Baldoni's camp, it was simple proof that nothing in her testimony backs up the smear campaign she's been shouting about for 18 months. But courtroom chess is only the latest move in a feud that started on a movie set and metastasized into the most expensive he said, she said in recent Hollywood memory. When Justin Baldoni snapped up the rights to Colleen Hoover's best-selling novel It Ends With Us, fans cheered the woman-centered pairing of Baldoni, known for gentle feel-good dramas, and Blake Lively, America's perennial sweetheart. But by late 2024, whispers from set said the chemistry had curdled. Lively allegedly flagged hostile conditions, uneven power dynamics, and safety concerns. A December 30 filing in New York federal court formally accused Baldoni and his Wayfarer studios of harassment, retaliation, and career sabotage. Industry pundits shrugged, these spats usually die in mediation, but the scripts kept leaking, the Twitter finger-pointing intensified, and both stars' fan armies dug trenches. Instead of cooling off, the dispute metastasized into an arms race of lawsuits, subpoenas, and strategic leaks. On January 16, 2025, Baldoni filed a thunderous 179-page countersuit, demanding a staggering $400 million from Lively and husband Ryan Reynolds, and even the New York Times. He framed Lively as a master manipulator who threatened phony harassment claims to wrest creative control and then weaponized her A-list connections to bury him in negative headlines. Legal analysts called the filings scorched earth. Fans called it man-bun feminism's last stand. But U.S. District Judge Louis J. Lyman wasn't impressed. On June 9 and 10, he torpedoed Baldoni's mega case in a brisk, blistering opinion, slamming it as more grievance than law. The dismissal left Baldoni nursing legal bruises and an 8-figure attorney bill, but it also freed him from discovery obligations he claimed were one-sided fishing expeditions. With the courtroom avenue blocked, his team pivoted. If they couldn't win in motions, they would win in the court of public opinion. Picture a wood-paneled conference room in Midtown Manhattan. Across a lacquered table, Blake Lively, stone-faced yet impeccably styled, flanked by 8 attorneys of her choosing. Opposite her, Justin Baldoni, PR pitbull Brian Friedman, and 11 more lawyers ready to object on cue. Before the first question ended, a source in the room somehow texted tabloids a running commentary. Lively's dusty rose power suit, the iced latte she never sipped, and even a snarky note about her entourage. By lunchtime, entertainment sites blasted headlines about a face-off between ex-co-stars, complete with fashion critiques. Lively's side seethed, Baldoni's camp shrugged, but both knew the real dynamite was the stenographer's transcript piling up page by page, each word a potential headline. The very next morning, Baldoni's lawyers attached all 292 raw pages to a routine letter, then asked Judge Lyman to seal them for 7 days, hinting that if Lively truly cared about privacy, she'd move for permanent sealing herself. Lively's counsel, Ezra Hudson, fired back hours later. The move was manufactured publicity, a stunt to force her client into looking afraid of the truth. Hudson demanded the entire filing be struck, calling it uncertified, uncorrected, and legally irrelevant. She accused Baldoni's camp of moonlighting as PR mercenaries, filing papers not to win motions but to feed the blogosphere. The skirmish turned an obscure procedural question into the most clicked headline on entertainment sites that weekend. Leaks didn't end with the filing. Over the next 48 hours, outlets from the New York Post to influencer gossip pages dripped inside information. Who escorted Lively, which lawyer scoffed at whom, and what smear campaign details were allegedly admitted under oath. Lively's letter claims those tidbits could only have come from Baldoni's camp, and were carefully curated to paint her as fragile, surrounded by handlers, while Baldoni strode in with nothing but truth and a single lawyer. This isn't the first time celebrity litigants blurred the attorney-publicist line. January subpoenas dragged Taylor Swift, Scooter Braun, and even YouTube pundits into the fray, turning discovery into headline bait. In Hollywood's new normal, a filing isn't a filing until it's trending, and nothing trends like secrecy, especially when both sides appear desperate to control the narrative. Judge Lyman has walked this tightrope before. He granted Lively protective orders over deposition logistics, yet he also publicly scolded both camps for weaponizing the press. Under federal standards, discovery material enjoys only a weak presumption of public access. Courts often seal drafts until they're finalized, yet they frown on parties using the docket as a billboard. If Lyman strikes the transcript, Baldoni loses a potential PR grenade. If he leaves it, or only seals 2 pages, Lively risks watching out-of-context quotes light up TikTok duets for months. Either way, the judge's ruling won't erase the internet's appetite. In 2025, a redacted line is an invitation for speculation, and speculation sells more ads than facts ever could. Unless a late-night settlement spares them, Lively and Baldoni will square off before a jury next March. Cameras won't be allowed, but sketches and live tweets will. Jury consultants warn that today's headline wars could backfire. Potential jurors may have prejudged the case or resent both sides equally. Legal experts predict 3 flashpoints: whether Baldoni's alleged conduct crossed the legal line into harassment, whether Lively's alleged smear campaign was protected speech, and whether either side can prove tangible damages in an industry where reputations rise and fall overnight. Settlements usually soar as trial dates near, but insiders whisper that bruised egos, not dollars, drive this fight, and both stars quietly believe a jury will crown them the victim. Strip away the celebrity glitter, and you find a cautionary tale about modern power. Me Too rewrote the script on workplace conduct, but it also created fertile soil for weaponized narratives, whether of victimhood or villainy. Add social media, where every sealed doc leaks in minutes, and you get a landscape where litigants hire TikTok strategists alongside trial lawyers. Critics worry the spectacle discourages real victims from coming forward, who wants their deposition outfit dissected by strangers. Others argue that public scrutiny is the only check on star power. Whatever the verdict, the Baldoni-Lively saga shows that in 2025, truth competes with click-through rates, and confidentiality clauses snap like twigs under the weight of fandom curiosity. So what's louder, a leaked transcript, or the silence that follows a judge's gag order? In a fight where every whisper becomes a headline, sometimes keeping quiet is the most deafening move. Question for you: whose strategy is winning? Team seal it or team spill it, and why? Drop your take below, because if one thing's certain, the jury of public opinion is already in deliberations. Thanks for watching. Until next time, take care.